Archivo no gel, y Mateo Sichi ve ibo no gel, y scoba ve para ikun lo leo molo, chupan vi hun ni malejo molo. Muy buenos días.
A very good morning, ladies and gentlemen. It's a great pleasure for me to open the 2300th meeting of the Committee on the Elimination of All Forms of Racial Discrimination. Distinguished members of the presidency, welcome this morning. We're going to begin the second part of our dialogue, looking at the periodic report of the United States of America. Yesterday, there were still some speakers on our list, so we'll be giving them time this morning to speak, and then we will be listening to the answers from the delegation. You will have an hour to make your comments and answers. We will then continue with the interactive dialogue between the distinguished delegates by yourself, sir. I would therefore like to ask colleagues to just take for their questions, given the limited time we have, in order to give the distinguished delegation the opportunity to fully answer all the questions and comments that were made yesterday. On my list, I have Ms. Dar, and I now give the floor to her. You have the floor, madam.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. Mr. Chairman, I think that you will allow me to have 7 African minutes, which is a bit longer time. Mr. Chairman, I would like to welcome the delegation from the United States and my colleagues. This is a delegation which is very dynamic and very competent from what we've seen on paper. And I'm sure that in the responses that they give us, that this will become clear. In particular, I would like to welcome the ambassador. And I would like to say that we hope that during his mandate, every time that the chair of a committee invites him, that he will honor us with his presence during the discussions that we organize and the events that the committee organizes to help move things forward. So, Mr. Ambassador, we welcome you. I would also like to governmental organizations, and I would like to thank them not only for the 1,000 pages that they have made us read, but I would like to thank them for the summary, especially, that they were kind enough to provide us with. That facilitated our work and were that we have time to. So I'd like to thank you for the documents and for what you've had and for testimony to us. I would like to say that if all civil societies were like you, then certainly the committee would be able to move forward in its work. I would also like to thank and commend our rapporteur, Mr. Amir, for the contents of his analysis and also for the way he carried out the work. We had him as a speaker. Now we know that he's also an English speaker. I hope that we won't use the French-speaking side completely of Mr. Amir. So, Mr. Amir, my congratulations on the work that you've done. And that you've United States yourself knew that you were completely bilingual, but we didn't necessarily know it before. Concerning our Mr. Vasquez, Mr. Maria said that at this session we will regret the fact that Mr. Vasquez doesn't have the right to take the floor during this meeting. He is a journalist without any equal, and he's very experienced. He's also to spend his time helping colleagues when necessary required. Much to Mr. Vasquez, and thank you to the United States for such and skillfully. So I have but Chairman say that absolutely everyone can say what they think about the relations that we have with each other. It's important for us to be able to say these things as I've just done. In November 2010, the United States went through the Universal Periodic Review before the Human Rights Council. And there were 227 recommendations that were made to them, if I'm not mistaken. If my calculations are correct, about 20% of these recommendations are of interest to CERD. And that's quite significant. That leads me to say that you of 20 years, that also shows that perhaps the education was useful. I understand very well the argument that you developed concerning the slow pace or the non-ratification of certain conventions. And I regret that until now, unless my information is incorrect, you have not ratified conventions such as the Convention on the Elimination of Discrimination Against Women, the Convention on the Rights of the Child, and the Covenant on Economic, Social, and Cultural Rights. Perhaps that's in the pipeline, I don't know. Perhaps you're in the process of ratification. I think it's necessary for you to know that from our point of view, even if you haven't overcome all of the domestic difficulties in your country before ratification, the process can be useful. We're here to help you. We're not here to monitor you. We're here to help you. And it would be a waste of time with respect to the rights of women. If the CERD Committee knew about a report and was able to study a report from the United States, then perhaps half of the non-governmental organizations who are here today wouldn't come before this committee, but they would go to CEDAW. And I regret the fact that all of the violence against women is not dealt with here. Most often this is violence against minorities, against women who are African American or indigenous women in the majority of cases, but not only. And all American women should have someone listening to their problems. That could help the United States to help adopt laws at various levels to help move forward the cause of women and to eradicate discrimination against women, which is something which we would expect from a great country such as the United States. Also, the Convention on the Rights of the Child. You already ratified 2 protocols. What about the convention? Why are you waiting to ratify it? We were shocked here by the testimony concerning children, not only children who go to prison, but those who are killed, those who are used as guinea pigs to test medication. All of this does not do anything good for the reputation of the United States. And I think that it is another voice than ours which should say that. The Committee on the Rights of the Child exists to say it and to deal with those problems. And I think it's time for you to appear before that committee as well. The same thing goes for the covenant. Out of the 2 covenants, you ratified 1 of them. But the second one is also important in our eyes. Everything concerning housing, health, education, all of that could be better understood and dealt with by that committee, the committee dealing with the Covenant on Economic, Social, and Culture, than us. That's an argument you could give to your Senate to sort of force their hand a bit. From time to time, that needs to be done. The parliamentarians need to have their hands forced, and to see the reality of the world and to tell them. The separation of powers in your country doesn't make it possible to have 10 or 20 senators, 10 or 20 congresspersons here to say how they could help with the implementation of the convention. Mr. Chairman, now I'll move on to the second focus of interest that I saw in the recommendations which were made to the United States during the Universal Periodic Review. And that is the recommendation which was made many times. I'm not sure how many countries made the recommendation. But the recommendation to create a national human rights institution. There again, you have an argument which would be that in different states, in different territorial entities, there exist independent institutions which help to protect and promote human rights. But at the national level, we think that a simple network of these institutions could do the work, but that's not the case. It is time for the United States, and it's necessary for them to create a national human rights institution, one institution that would be independent at the federal level, which would be in line with the Paris principles. We are very interested in this. We have a great interest in this because in this committee, we have an original procedure, which is to invite the national human rights institutions which have status A, and they sit in a separate place in the room, and they tell us what they think about the policies to promote and protect human rights in the country. That institution is something we're lacking here. It should have been sitting right here in front of us in the middle, at the middle table there, but it's not here. We miss having such an institution. We won't say anything different. We would have an opportunity to talk to them. They would have been a reliable intermediary between the NGOs and the state party. So there's a gap here. There's something missing. And we would indeed ask you to fill that gap as soon as possible. Mr. Chairman, see in the core document, there's a paragraph paragraph 55, which says that even in the Virgin Islands, the American Virgin Islands, there is a commission which plays the role of a human rights commission, and it receives complaints against racial discrimination. This is significant because even in non-autonomous territories, there exist institutions. But what is the impact at the national level? Now moving on to the point which is going to be the focus of my intervention concerning non-autonomous territories. Mr. Chairman, there are three non-autonomous territories currently administered. That is the Virgin Islands, Guam, and the Samoas. These are the three territories, and I can't say anything different. Three territories. For us, in light of Resolution 1514 of December 1960, which concerns granting of independence to peoples and territories, to colonial peoples and territories, I can't say anything different than what I've just said. These are the only three territories that are administered by the United States. And for as far as CERD's mandate is concerned, how does that concern us? Article 15 of our convention subjects us to a double obligation. That is to consider the copies of petitions, reports, and other information that come in from competent bodies of the United Nations. And that is mainly the Trusteeship Council and the Special Political Committee. So we consider these petitions, reports, and other information in light of the convention, and then report to the General Assembly. The second obligation is upon the administering power. They have the obligation to inform the committee in their periodic reports about measures they've taken to implement the convention in the territories that are under their responsibility. Unfortunately, for some years now, we have not been in a position to carry out this mandate. As I've done with other administering powers, I'll do the same with you. I won't without any bias. Because as I said, it's not a matter of taking a star off your flag. Even if we're talking about self-determination, that's not the type of self-determination we're talking about. We don't have a mandate to take any star off the U.S. flag. Our mandate is what I've just said. It's contained in Article 15 concerning those three territories that I mentioned for the United States. So for your case, I think that you have provided the maximum of information, but I do have a comment to make. I hope you will take it into account when you submit your next report, when you draft your next report. What I will say is that in the core document, you listed the principles, and in the explanation you said that you talked about the actions that you're undertaking in these territories. But I think it would have been better to have one chapter entitled Non-Autonomous Territories and say what you have in principle and in practice concerning these territories. That would have helped us to see more clearly. And for example, if we look at the case of the Samoas or the Virgin Islands, I would have been able to say what are the cases that are considered by the commission, the human rights commissions that were created to promote and protect human rights. For us, that would have already been a basis for looking at implementation of our Article 15. And so, Mr. Chairman, I see you're looking at me. You're giving me a look, so I'll stop there. I will say that I'd like once again to thank and commend the United States for a report which is a significant improvement from previously. It is very rich, perhaps too rich, but it can only be improved after this and with the next submission. I'd like once again to thank the NGOs and say that unfortunately here we can't take into account everything that they said. As you see, our time is limited, but we have seen their combat. In Africa, we had freedom, people fighting for freedom. They're also here, they're fighting for dignity, and I would like to say that we will take their fight for dignity into account. Thank you.
Muchas gracias a usted, señora.
Thank you very much, Mr. It's not that I'm giving you a look, it's just that time is really pressing right now. I now give the floor to Mr. Wang. If we can just stick to the 5 minutes, I'd be grateful. Mr. Wang, you have the floor.
Okay. Thank you, Mr. Chair. Mr. Chair, I wish to join hands with what Mrs. Da has just said. In gourmet terms, we cannot use the pressure cooker to have a good meal. Everything must be done in its time. And this also applies to the delivery of a presentation of each and every mandate holder. So I do hope that the number of minutes which have been more or less, quote, imposed on us, there could be some leeway in the sense that we don't want to be uncivil, and of course we want to be able to thank, for example, the delegate and our colleague Mr. Amir for all the efforts they put in the presentation of the country report, and of course the observations. So, distinguished delegates, I want to join my colleagues to thank you for the frank and candid periodic report you have produced. I want to thank also Mr. Amir for his unrestrained efforts in the concept, analysis, and write-up of his well-detailed observations, which cover far and wide the areas of discrimination and inequalities prevalent in the USA, as can be gleaned from the periodic report itself, as well as from important input from the civil society. I know time is short, and we've been reminded that we have to make headway. The first point I want to make relates to the majority decision delivered in 2013 by the US Supreme Court in Chouette, in which the court upheld a 2006 Michigan voter referendum that amended the state's constitution to make affirmative action illegal in public education, amongst other areas. Now, there is information that in the 8 states that have passed such laws, minority enrollment has dropped significantly. In the US tertiary education system, tertiary education is often referred to as college. Elsewhere, it is more commonly referred to as university. One may ask, what's in the word? What's in the name? I want here to join my colleague Mr. Lindgren Alves in his colorful observations yesterday on the importance of attaching proper meaning to words. The very word university derives from universal, which is far wider than parochial. So the university is meant to be a place of meeting and learning from people coming from different communities and ideally from different parts of the world. And one can but shudder at the thought that, that universities in 8 states within the federal state of 50 are compelled to practice admission procedures which end effect is the institution of segregated places of learning. Is it not good sense that the top league universities in other countries have always opened their doors to welcome undergraduates from different parts of the world in the true spirit of what a university is meant to be? A space of diversity, of bringing and sharing, of exposure, to other ways of living and thinking, and of learning, not only academic, technical, or professional matters, but more importantly, how to become accomplished citizens of the global world in the wider meaning of the word education. The role of the university has never been that of a sausage machine, through which the products come out in the same size, shape, and possibly color as well. So coming back specifically to Chouette, I would like to limit myself to mention the practice of this committee whenever it comes across situations where conditions exist for affirmative action to be invoked for the benefit of minorities to make the appropriate recommendations. I would ask the distinguished delegations for its views. As to whether such situation does not exist in those 8 states which have by law removed affirmative action in the area of education. The answer may be one which the French would term as a vérité de la palisse. I do appreciate that those undergraduates who would have been admitted to one particular university or two, had affirmative action been applicable, would have been channeled to other segregated universities. This can only be second best for the university as an institution and the state as a responsible party for providing what is best for its population. Most of all, those who are in the front line, the undergraduates, would have missed the chance of a lifetime, sharing a unique experience in learning to live in a spirit of unity in diversity through tolerance, respect, bonding, and probably appreciation as well, coming to realize that there's a wide gap between differentiation and discrimination, and that there is only one world, if not one and the same boat to share. The second and last point of my intervention, is in relation to paragraph 19 of the periodic report. I wonder whether the term settlement, which has apparently been entered between the Department of Justice with the juvenile court that is mentioned in the report, is used in its proper context. Perhaps this is an example of attaching meaning to words in a context different from my reading. The role of the courts is, of course, to try any case that is brought before it and to decide the issues on the strength of the evidence and the law. In true spirit of the principle of separation of powers, the executive cannot interfere with the judiciary on how a judicial matter should be decided. I would be grateful if information be provided on the quote settlement reached and how it came about. Finally, I shall fail in my duty. As a Mauritian and as a mandate holder of the CERD, if I were not to mention the collateral effect of the history of the decolonization of my country, Mauritius, in 1968. Shortly before Mauritius obtained independence, the colonial masters, Great Britain, detached the Chagos archipelago from Mauritius, contrary to the relevant UN resolution against dismemberment of territories or former colonies. There were a number of Chagosian families living in the various islands forming part of the archipelago. This information was deliberately withheld by Britain to hoodwink the international community during the detachment process, which was done by way of an order in council. Diego Garcia, which forms part of the Chagos, was thus leased to the United States of America for use as a military base. Now, those Chagosian population have been displaced to the Seychelles and Mauritius forcibly and have been unable to return to their home, and their problem, the problem of serious discrimination, is still ongoing. I implore this delegation to look into their plights and to bring whatever amount of relief which is practically possible now and for the future. You can always send them back to the UK to settle their problem, but that would not be consonant with the spirit of freedom of your great country. Mr. Chair, I have done, and I thank you.
Muchas gracias.
Thank you very much, Mr. Yuen, for your statement. Ms. January Bardil, you have the floor, to be followed by Mr. Calaf.
Thank you, Mr. Chairman. Like my colleagues, I would like to echo all the welcomes that have been extended to the American delegation. And it's really wonderful to see this diversity of people. I think it really demonstrates what is possible, and also that affirmative action actually does work in many ways. I mean, I'm not suggesting by any means that the diversity is necessarily a direct result of that. But most of us who live in societies where there have been inequalities and have adopted affirmative action as a model for making a difference have experienced the value of it. So I'm particularly pleased to see, as somebody said yesterday, one of my colleagues, the rainbow nature of your delegation. And also to thank you for the reports, both the written report yesterday and the reports that we've had to read, as well as the verbal reports that we were offered. And also to the non-governmental institutions, the civil society organizations that we've been able to engage have really made tremendous efforts in enlightening us further on what is going on in the United States with respect to the implementation of the ICERD. I often have to remind myself why we are here, also as committee members. And that reminder is really to remind where this particular, the ICERD was originated, directly from the United Nations declaring apartheid as a crime against humanity and the reason for the ICERD. And it was specifically directed at the manner in which Black South Africans were treated. And so most of my comments really will also be very much directed at the particular experience of African Americans and people of African descent who live in the United States. Now, I prescribed work, and the reason why I reminded myself was also because I wanted to remind myself that this committee was actually created by states parties to this convention to monitor the implementation of the substantive rights and the normative part of the ICERD that define the basic rights and fundamental freedoms in the areas that are addressed by our convention. We have to conduct our own research, and we have to comment on the basis of the reports that you provide to us in order and see what it is that is being done to achieve both the normative and your developmental responsibilities. And when I was reading the report, I basically came to summarize it to three conclusions. That the first intention of most governments, as well as that of the United States, is to deliver justice. And this is what most of the conventions, because there are legal instruments, attempt to do. And I will come back to the issue of delivering justice, because I think justice is very different from the rule of law, but using the rule of law to deliver the justice. The second objective that I have picked up in the reports that we examine all the time is that most states also do what they do to ensure security, to give their citizens a certain level of comfort in the sense that it's a peaceful state they live in, and the principle of equality is certainly something that many of the states aspire to. And I don't for anything doubt that that's the case in the United States. And that's why it's such an attractive destination to people who wish to to better themselves, as well as people who are seeking refuge because they experience inequality and discrimination in their own countries. And the last, I think, objective in what we do is that most states, including the American state, is doing its work to deliver basic services such as shelter, to deliver water, to deliver food, to deliver energy, to deliver health and education to its citizens. And these are basic needs. They are not needs that we all don't have. Each and every one of us in this room can relate to the fact that we require these basic needs. And then, of course, the way, the vehicles through which these are delivered, all three, justice, security, and basic needs, is through a inclusive political, social, economic, judicial institutions that fairly and equitably respect the fundamental human rights of all their citizens and willingly work together to deliver justice, security, and basic needs. And so the ICERD, I see the ICERD as really assisting in addressing very specifically the issues to do with race and racism and justice around that. And of course, lastly, when states do use these institutions, they also have to ensure that they have sufficient resources, they have efficient economies that ensure that citizens and individuals and corporates have access to land, have access to water, finances, energy, etc., so that they too can contribute to the economy and help themselves meet their own basic needs. And that's really in a lump sum what I understand to be the role of states as well as the role of our convention. And so when all the states adopted all the conventions, the proclamations of the United Nations, they believed that they could make a difference. They could make a big difference because of the resources that they hold, as well as the political power that they hold. And I think through decentralization, through federal states, and understanding that the delivery takes place better at the cold front of the communities, the usefulness of decentralizing is also borne witness to. And recently, it has become cities. Cities are becoming the place at which service delivery is best done. So my question really is, as we read the report, and as we analyze it, and as we try to understand it, and really commend the states party yourself for the effort that you yourselves have made, of course there are gaps as well. And when I was reading the report, I thought I should ask, when a law is made to address a specific issue related to racism in the United States, does this law exacerbate the issue? Does it comply, or simply is it just about ticking a box? Is it simply reform? And I call reform when you simply move the chairs around. Or is it transformative? Does it make fundamental change? And I think that's a question that we have to ask ourselves when we make a difference as a state. And then another issue is, if it is transformation and if it is transformative, how are we going to measure it, and how are we going to know that we've actually achieved our goals? And yes, I'm being a little bit verbose because I'm trying to understand the complexity myself. And so I will ask very specific questions related to the issue of justice, to security, as well as to basic needs. And my first question is, there's a lot being said about the incarceration of African Americans in the United States. And I'm not excluding the other minority groups, I'm just making a very specific mention of African Americans and people of African descent. And by this, I'm not just talking about people who are born and bred in the States, but also Africans from other parts of the continent, who go to universities, who go and use the endless opportunities that are there for them to fulfill their own ambitions. But I mean, it has been mentioned by my colleagues in yesterday's dialogue that incarceration of African Americans is something that many of us are very concerned about it. And the war on drugs, unfortunately, a very important social issue that is not just rampant in the States, but in all our countries, especially, I mean, my country, we have a serious issue about drugs. The issue is, how do you address it? Is it through imprisoning people, or is it through using it, seeing it as a social issue and addressing it socially? The answer lies somewhere in between. Civil society groups that have reported on this issue claim that 1.7 million children have to cope with the immediate and long-term consequences of their parents being incarcerated. And this is a very worrying statistics. And the question, therefore, to the American government is, how does the state party plan to legislate into law alternatives to this parental incarceration based on laws that imprison people rather than help them in a different way, which would also then prioritize and protect the children of people to their right to families and integrity. The children in this instance lose their own sense of security, they lose their self-esteem, they lose the trust that they have of other human beings, and their rightful place in the world is really compromised. And so I'd like you to perhaps give us some sense of how this problem, this issue, can be addressed in a way that does not have this very negative effect on children. The second issue, on the justice issue, again relates to something that was mentioned briefly yesterday on the migrant border crossings. Is it the case that those treated are also treated as criminals and not necessarily as civil cases? And my question is, how will the state party reinstate the policy of treating these improper entries? And again, entry is not just from South America, entries from many other parts of the world, including Africans and people from other countries that come into the United States. We would like to hear and read more reports about how this process of dealing with it can be more a civil approach rather than a criminal approach. Then I would also like to ask the question, is it the case, because this, again, we have had to listen to the civil society reports, and we ask them without acknowledging that the source is from some of them. Is it the case that more than 20 civil rights era activists who were very active in defending human rights are still in prison in the United States? And to what extent is the state, first of all, conscious of perhaps thinking about how to deal with this particular one. Is it the case that the activists from particularly African American and Latino and Native American communities will linger in prison for life, especially as most of them apparently are not very well, and the conditions in which they live are rather unpleasant. And of course, I've done now with the justice issues that I wanted to ask, and like to go to the basic needs ones. On the housing question, again, lots of questions about housing, particularly the right to shelter. Here, the report, as well as civil organizations, have expressed deep concern of the discriminatory impact on American and Latino communities and Black communities, and specifically of the subprime loans between 2004 to 2009. And this already resulted in substantial loss of personal wealth for some of them. And the question is, does the state party plan to address this racially discriminatory impact of earlier mortgage foreclosures? And lastly, in terms of the basic needs issues, I really would like to urge the state party to focus, because our convention does have a history, it does have a context, it has evolved over the years, but we also need to be very, very, very clear about what exactly we are dealing with when we talk about racial discrimination. So I'd like to echo what Ms. Dar said and say that we would like to see other committees deal with some of the issues that are brought to CERD. I really, really appreciate the comment she made in that regard. There are the issue of violence against women, the issue of rape against women, and particularly African American women in the States, is really serious. The whole world at the moment, sexual violence has increased. There is not one country without exception where the sexual violence has not increased. But what our focus is really to the extent to which sexual violence dehumanizes all of us, men and women, but particularly Black women, is something that needs very, very concerted attention. This also includes the medication. Apparently, there's the treatment through the medical treatment of women who are incarcerated is also something that civil society organizations are not particularly charmed about. That mental health and psychiatric treatments are so destructive that it's not worth, in fact, making that intervention. And I'd like to stress that the impact on African Americans is particularly harsh. And lastly, to conclude, Mr. Chairman, without taking too much time, I think we are having this meeting at a very seminal time in our history, actually. The first is that it'll be 20 years since the American state has ratified CERD. CERD will be 50 years old next year. You know, our charter, the very first, the charter will be 70 years old, I believe, next year. Everything is culminating in 2015. The Millennium Development Goals will be reaching their end, and all states are looking at what they have done in the last 15 years to implement the Millennium Development Goals. The Beijing Platform for Action has reached its 20th year next year, and it's also being reviewed to the extent that women are being addressed in the Platform for Action. And I think in shaping the new Millennium Development Goals, or as they will be called, Sustainable Development Goals going forward, where the General Assembly will adopt them next year, we really urge the State Party to see this as an opportunity, to really mainstream both gender inequality and the intersection of race and gender, and mainstream the race issues in Millennium Development Goals, so that a real concerted effort can be made for 2030 for us to achieve these goals. And I think it would be such a wonderful opportunity not to miss. And it justifies really us taking this opportunity and making it work for yourselves, for your citizens, but also making it, it'll affect obviously the work that we in CERD will be doing, because hopefully the targets that you set yourself and the mainstreaming of race and gender, especially race in our case, would really make a big difference to how development goals are met as well as others. So with those few words, Mr. Chairman, I know I've extended my time as well. I thank you very much.
Muchas gracias.
Thank you very much, Ms. January Bardil. Mr. Kalaf, you have the floor, to be followed by Ms. Hojueto.
Merci, Monsieur le Président.
Thank you, Chairman. I would like to echo my colleagues' words and welcome the distinguished delegation of the United States. This reflects the wealth of the American social fabric, and we are very delighted to see so many of them here today. We would like to greet representatives of civil society, a very active, energetic civil society, activists which are working for a better future. I can't go without mentioning the excellent quality of Mr. Amir's report as well. He was particularly focused and touched upon a broad range of issues. Mr. Chairman, you know that all countries in the world are working to better mankind at a time when the diversity is coming to the forefront. The United States is the flag bearer for diversity. The United States symbolizes a great deal of values for the world and for mankind. We are aware of this. Indeed, if we simply read the report, we will see how structured and targeted that report is. It's a very consolidated report. When it comes to the report, I would make three main comments of a technical technical nature. The first comment, under Article 6 of the American Constitution, it talks about the different values given to the treaties. They are of the same legal value as the Constitution. But what do we do if there is a contradiction between the treaty and the Constitution? Which prevails, the Constitution or the international treaty? This is a question which I believe is of vital importance, legally speaking. Now, of course, technically, we could look at much more in-depth matters, but I'd like to make two further comments regarding the report. Firstly, there is no national plan to put the convention into place, and I really would hope to see this comment being taken forward by the delegation across the complexity of the United States and at the different levels of responsibility, state and federal. In order to do that, it would be worthwhile creating a national institution. Said national institution would be tasked with implementing this national plan. Of course, this technical point might be left there. However, I think it is the key testimonies from civil society that these people wanted to share with us that in fact would push me to ask several questions beyond the simply technical aspect of things. Speaking on a personal level, I was truly moved by the sensitive approach and sensitive nature of the testimonies given to us by the victims. as they seek justice. I really was left with a strong impression of vulnerable, marginalized groups such as indigenous people, persons of color, women, students, migrants, who have the view that they're living in a struggling society. We'd like to hear the views of the federal government on the causes of that view, the views that they hold. Do they not hold these views because they are finding their lives to be extremely difficult because of their marginalized situation? What is the government doing to remedy that situation and to ensure that these people feel that they are protected on an equal footing on the territory of the United States? A further issue I'd like to touch on now. The United States have prisoners who are being deliberately held on another territory, beyond the borders of national territory. This means that these prisoners are not held under the fundamental safeguards offered to them by the American law on American soil. Consequently, this means that these people are not held under the umbrella of our convention. I'd like to know how the United States intends to remedy that situation. Moreover, the report talks about the discovery in Texas on the 24th of June 2014 of a mass grave where 110 corpses of migrants were buried. These bodies were buried without any identification and without any formal procedures. My question then is whether there is any official information as to that matter. Has there been investigation carried out? What is the American government doing to reassure migrants, even those who are attempting to enter the territory illegal? What is it doing? What is the government doing to assure humane treatment of migrants? How are the tens of thousands of children who are arriving at the US borders from countries such as Guatemala, El Salvador, Honduras, how are they being treated? My last question is on indigenous peoples. We were alarmed as we heard about their situations at several different fronts. We were alarmed by the loss of their culture and that their children have been taken into schools where they are not able to get in touch with their culture and with their roots. We were alarmed as we heard about their concerns regarding their living conditions, the lack of water, or the contamination of this water, the pollution of the water, their lands, their heritage, and indeed their concerns about their very survival. These issues all fall under the spirit of our convention and would bring me to remind you of as I say, the fact that you are the flag bearers of these very key values to society. Thank you.
Muchas gracias a usted, señor.
Thank you very much, Mr. Kalaf. Ms. Howard, you have the floor.
Thank you very much. Thank you, Mr. Chairman. Like my other colleagues, I would like to welcome this very strong delegation from the United States, which has come to talk about the efforts they've made to reduce or eliminate racial discrimination in the 50 states and other territories of the United States. The United States, as we know, have a multiracial population, multi-ethnic and multicultural, one which is unlike any that exists elsewhere in the world. I welcome the dynamic civil society from this country. We've seen that they're determined to help move things forward and help to combat racial discrimination. I would also like to commend our rapporteur, who had a very wise and detailed analysis of the situation. Among the subjects included in the analysis, my concerns have to do with subjects 1, 2, 3, and 5. On subject 1, in the core document, in paragraph 78, we read, and I quote, that the power of state governments is vast. Each state is in many respects a sovereign entity, free to promulgate and enforce policies and laws that pertain exclusively to that state, limited under the federal constitution only to the extent the relevant authorities have been delegated to and are exercised by the federal government or by other federal constitutional requirements. End of quote. Are we to understand that the recommendations of our committee are taken into account to a different degree by the various states? What is the role of international treaties and conventions ratified by the United States in such a federal state? The response will enable us to understand why racial discrimination is stronger in some states and is more established in some states, and to help understand the measures and programs carried out to eliminate it. The importance of a national human rights institution no longer needs to be proven to the United States. My colleagues have talked about this already. Such an institution would enable the committee to have an overview of the situation of human rights in the United States. And it would also enable us not to have to study so many documents from civil society. The federal government should be able to find the means to create an appropriate mechanism which is responsible for ensuring the coordinated implementation of the convention at the federal and local levels, so as to reduce the disparities in application of the convention at the various levels. On subject 2, discrimination against national or ethnic minorities. With respect to education, in social and economic and cultural indicators included in the state report, including at the level of education, there are no statistics about the schooling rate of American children in school and preschool and primary school for American children in general and children who belong to ethnic and national minorities in particular. These statistics would have enabled us to see the efforts being made by the government to encourage basic education for children of color. Alternative reports have talked about child labor among children who belong to ethnic minorities, particularly when they work in agriculture. Now, the right to education is not a federal obligation. It is managed by the states. So in the United States, if we understand correctly, there are 50 education systems. So it was reported that in 2013, the city of Chicago closed 49 primary schools, which were mainly in African American low-income neighborhoods. The pupils and the teachers were majority African American. This is discrimination against these people. It also can lead to violence and delinquency. The American government should investigate what happened in Chicago and take measures to ensure that these actions are not repeated. It is jurisprudence which led to the situation of education, the education system being determined by each state. So we think that this principle can evolve, and that jurisprudence and case law can help to make sure that things evolve and change. In the area of health, colleagues have also talked about this. 40 to 60% of African American women have been victims of rape or are still victims of rape. This is a heavy burden upon, the rape of a woman is a heavy burden upon the health system. And it's a heavy burden for the woman. It lasts her whole life. Also in the area of health, we've seen the excessive and non-necessary prescription of psychotropic medications to young people who belong to minorities. This affects their mental health, the mental health of these adolescents who are future adults. This type of treatment particularly affects African Americans. 60% of youths from this minority who are held in detention have mental health problems. The federal government and the state governments should look at the administration of mental health of adolescents at their respective levels, including with respect to underprivileged racial minorities. On reproductive health for women who are held in detention. In the alternative report, inter alia, it says that women who are held in detention, who are incarcerated, are often the victims of poor diagnosis with respect to their reproductive health. Often they are subject to operations such as hysterectomies, and inappropriate medications are prescribed to them. Sometimes this leads to sterilization, and these women don't necessarily give their consent or know what they are undergoing. The government should look into this phenomenon and provide statistics about reproductive health of women who are minorities who are incarcerated. On subject number 3, discrimination against indigenous peoples. What environment does the state and federal governments, if the state and federal governments are exploiting natural resources of indigenous peoples and their environment, this often has an effect on their culture. Is the federal government looking at the environment of indigenous peoples, especially after hurricanes, for example? On subject number 5, access to justice. I would add access to justice and the rights of racial, ethnic, and national minorities. The Federal Supreme Court recognized the right for a criminal to have a lawyer to defend them. A lawyer must be provided to them in the case of civil proceedings. But in the United States, poor populations, those who are living below the poverty threshold, do not have the capacity to have a lawyer because they don't have the resources when they're facing critical situations in their lives, such as expulsion, when they get kicked out of their houses, evictions, discrimination in the workplace, refusal to provide medical assistance, disputes with credit card establishments and so on. They don't have the means to undertake the procedures to ensure that their rights are upheld. When some categories of the population cannot enjoy their rights or fully have access to justice, there exists discrimination. And this discrimination is institutionalized. The federal government should therefore document these situations and carry out programs to ensure access to justice for all American citizens without any distinction, to provide a legal aid program that could be implemented in all states. With respect to the impact of incarceration of parents upon their children, this has already been mentioned. In particular, with respect to combating drugs. And I would like to welcome the fact that the state of New York, as the official delegation told us, has made an effort to find alternative penalties instead of imprisonment for minor infractions related to drugs. This solution preserves family integrity. It can help preserve the family and enable the children to continue their education. This is something that other states might also consider. Without a doubt, we all have the right to personal safety and security. But the enjoyment of this right in the context of the United States justifies the measures to limit the circulation of weapons and arms, especially with respect to African American indigenous peoples and their effect upon them. Efforts should be made to reduce the circulation of firearms. To illustrate this, I would like just to ask, what has happened to the person who killed Trayvon Martin? Is the person who killed him currently free? Certainly, we know that the United States are making efforts at the federal, state, and local level to reduce racial discrimination and to eliminate it. But this is not enough. The federal states and the federal government and state government must make more efforts and implement programs to achieve this, and we encourage them to do so. Thank you, Mr. Chairman.
Muchas gracias a usted.
Thank you very much, Mr. Huerto. I now give the floor to Mr. Kut. I'm not discriminating against anybody, but I would urge him to be as brief as possible. We have already spent 4 hours with the delegation, and we've yet to hear their responses. Mr. Kut, please be as brief as you can. Thank you.
Thank you, Chairman. I promise I will be very brief, given that all my colleagues exceeded their times. I would like to join all my colleagues to congratulate the US delegation for its high level, for its diversity, and I didn't fail to notice that an effort has been also made to include several representatives of a neglected minority group, that of left-handed people. We are a forgotten minority, and we represent 10% of the world population, Mr. Chairman. I have 3 very brief points to raise, since my colleagues have aptly formulated their questions, which gave ample possibility for which will give ample possibility for the delegation to answer, including the very extensive and fully covering report of Mr. Amir. I have briefly 3 issues to raise. One is about the federal system of government and the obligations under the convention. That is, what kind of mechanism, concrete mechanism exists to implement the obligations under the convention among federal, state, local, tribal, and territorial governments. We are aware of the efforts, but I'm interested in concrete mechanisms which would have measurable effects. That's my first point. The second point is about another possible mechanism whose existence I'm not aware of whose existence I'm not aware of. Is there anything, any system of supervising the policy of revocation of citizenship to make sure that it is a just policy and it doesn't discriminate against particular groups? My third point is about racism in internet. We are only fully aware of the US approach to freedom of speech and how everything else becomes a function of that particular right. But we are also aware that there is no hierarchy of human rights. All human rights are equal. We shouldn't discriminate between them. And this insistence of one human rights over others leads to consequences that reach beyond the borders of the United States. By this, I mean the serious issue related to racism in the internet. Wherever you are in the world, you are safe if your service provider is in the United States, irrespective of the rules and laws of the countries that govern the right to be free of hate speech and right to be free of racism. What is the mechanism in the United States which could possibly give an answer to this demand that there is a need to regulate certain illegal behaviors everywhere, anywhere, as much as possible, so that people could be free of hate speech and be protected against racism. With that, Mr. Chairman, I terminate my intervention. Thank you.
Muchas gracias, señor.
Thank you very much, Mr. Kut, for your understanding and brevity. Distinguished members of the delegation, Your Excellency, you've had a real avalanche of questions today and yesterday. You'll have between an hour and 20 and an hour and a half to answer the very many questions and comments from committee members. You now have the floor, sir.
Thank you, Mr. Chairman. On behalf of the entire U.S. delegation, we'd like to thank all of you for your important and thought-provoking questions. Particularly thanks is due to the rapporteur, Mr. Amir, for his comprehensive points. We will now address the question we received yesterday. We will do our best to address this morning's additional questions, but may leave some to the interactive dialogue. We look forward to having a fruitful dialogue on the progress we have made in the elimination of racial discrimination, reduce racial disparities, and other related issues. We value your input on how we can make further progress. We will address the questions in that spirit, while bearing in mind there may be cases where we believe the issue does not bear directly on our convention obligations. In order to address as many of your questions as possible in our allotted time, we have largely organized our presentations by agency which may result in different speakers touching briefly on the same issue. Please do not take the brevity of our responses as minimizing the importance of these issues. With that, I will turn to Scott Busby from the State Department to start our responses.
Thank you, Ambassador Harper. As you will note, we have expanded further our presence here overnight, and it's a good thing we're probably finishing at 1 o'clock today, or else we might take over the whole room if you gave us enough time. I will begin by answering the questions raised by Mr. Amir and several other committee members about how we seek to ensure full implementation of the convention. My colleague, Ms. Rajpal, will also provide a legal perspective on these issues. First, let me say the United States is deeply committed to effective domestic implementation of all of our human rights obligations, including those under this convention. Given our federalist system, such implementation is a true collective effort among federal, state, local, tribal, and territorial governments. My colleague Paula Schrieffer yesterday described some of the ways we have increased our engagement with these actors in recent years. Many of you raised the issue of a national human rights institute. That is something we are still considering within the U.S. government, although I would note I believe that even if we did have such an institution, I think we would still get as many shadow reports from the civil society organizations as we received with this report. So I don't think it would solve that problem, but it is an issue we are still considering. Although we do not have such a national human rights institution, we do have multiple complementary procedures and mechanisms to reinforce our respect for human rights. At the federal level, for instance, the White House leads a high-level interagency policy committee on human rights that oversees the implementation of our human rights obligations as well as our commitments under the UPR process. Additionally, we have the Equality Working Group, which several of you have mentioned. This is another effort by the administration to expand federal leadership and coordination specifically on issues related to racial discrimination. This group encourages federal agencies to work together on these issues and share best practices, and serves as an additional forum for outreach to civil society and other stakeholders. We will consider Madam Crickley's recommendations on the role of this group as we continue its efforts. Furthermore, federal agencies regularly monitor developments at the state and local levels to ensure that we are complying with the U.S. laws through which we implement the convention. For example, the Justice Department has challenged laws in Texas and North Carolina under the U.S. Voting Rights Act. Many federal agencies also provide information, training, and funding at the state and local level on domestic protections that relate to the convention. For example, as we speak this very week, the Equal Employment Opportunity Commission is hosting its annual conference for state and local fair employment agencies. And at that conference, they have included a dedicated session on U.S. human rights obligations, including this convention. As part of our increased efforts, the Department of State has written to state, local, territorial, and tribal officials earlier this year to remind them of our treaty obligation and our upcoming presentations, including this one. This and similar letters, plus other treaty-related information, have been made available to the public on the State Department's website. We also intend to post the concluding observations of this committee on that website soon after they become available. Regarding Mr. Amir's question about American corporations whose operations may affect the rights of indigenous people and ethnic minorities, we strongly support accountability for corporate wrongdoing, regardless of who is affected, and implement that commitment through many domestic laws and regulations, as well as our deep and ongoing engagement with governments, businesses, and NGOs on a global level. The U.S. supports accountability through a variety of mechanisms and forums that are listed in our report. Two recently adopted measures for improving corporate accountability are the Ending Trafficking in Government Contracting Act, which prohibits in all federal contracts acts that directly support human trafficking, and the recently adopted U.S. Burma Responsible Reporting Requirements, which require companies investing over a certain amount in Burma to report on the human rights impact of their policies and procedures. We also support efforts by multilateral development banks, including the World Bank, to improve their environmental and social safeguards. Finally, I wish to acknowledge the emphasis that many committee members have raised regarding the robust participation of American civil society in submitting shadow reports and in providing comments to the committee members. The United States views the participation of civil society as an absolutely essential element in ensuring that we live up to our human rights obligations and that we continually work to correct areas where we fall short. It is for this reason that we dedicate tremendous effort to engaging with civil society ourselves and ensuring that civil society around the globe is able to engage with the UN system, including with all treaty bodies, free from intimidation or reprisals. We express our hope that the members of this committee will raise this important issue in reviews of all states parties to the treaty and to your own governments. I now turn the time over to my colleague, Sabina Rajpal. Thank you very much.
Thank you, Scott. My name is Sabina Rajpal. I'm the Acting Assistant Legal Advisor for Human Rights and Refugees at the Department of State. I will address the questions we heard about Guantanamo detainees and legal questions related to the convention. Mr. Amir and Mr. Avanatov, you asked about Guantanamo detainees, and as Mr. Amir noted, we have established a periodic review board to review whether continued law of war detention is necessary for certain Guantanamo detainees, and to identify additional detainees that may be transferred, subject to national security and human treatment concerns. The review board has conducted 9 hearings so far, in which detainees were able to participate along with their personal representatives and private counsel, and have determined that continued detention of 4 of these detainees is no longer necessary. This process is conducted without distinction on the basis of race, color, descent, or national or ethnic origin. Moving to Mr. Diancanu's question on how our federalist system protects against state and local violations of human rights, I will note an overall point that one single approach is not necessarily the best suited, most effective, or most efficient way to achieve full implementation in a specific state or locality. Moreover, given the size of our country, state and local officials are often located closer to the people they serve and are in a better position to solve their problems. You will hear about more local innovations and collaborations from our state and local representatives today, and you'll also hear from the Department of Justice on how they work in providing a check when state and local authorities are not protecting human rights. Mr. Basiot, you asked about the status of the convention under domestic law. As you indicated, under the Supremacy Clause of our Constitution, treaties are the law of the land, and therefore we take our convention obligations extremely seriously. At the time of ratification, we determined that there was no need for the treaty to be directly enforceable in U.S. courts, and issued a declaration that the treaty as a whole would be non-self-executing. This declaration does not limit the scope of our convention obligations. It only addresses the manner of implementation. We implement our convention obligations primarily through compliance with the U.S. Constitution's equal protection guarantees and federal, state, local, and territorial anti-discrimination laws, and vigorous enforcement of these laws by many of the agencies before you today. We also got questions about our reservation regarding private conduct. I want to note that our Constitution and federal laws do in fact prohibit a significant amount of private racial and ethnic discrimination in a wide range of activities and settings. We did make this reservation, however, not because we broadly permit private discrimination in our society, but to account for the small number of areas in which the convention may conflict with our system. We've also received several questions, including from Mr. Amir, about our reservation to Article 4 and our position on hate speech. As you will hear during our presentation today, we are deeply committed to combating racial and ethnic discrimination and intolerance. However, we believe that banning hateful speech is neither an effective approach to promoting tolerance, nor is it an effective role for the government to play. While we appreciate the factors laid out by you in General Comment 35, and I note that our courts have sometimes looked at some of those factors themselves, the general comment, like Article 4, goes beyond what our Constitution allows in terms of restrictions on speech. And it also goes beyond our values in terms of what we believe should be restricted. Indeed, we protect freedom of expression because the cost of stripping away individual rights is far greater than enduring hateful words. This is not to say that we don't think there is a role for government to play in promoting tolerance. For example, political leaders from the president down to state and local officials speak out and condemn racist speech. We also use tools such as legal protections against discrimination, hate crimes prosecutions, proactive governmental outreach, education, and the vigorous defense of freedom of expression, including for minorities, so that we can combat intolerance. With that, I will turn it over to Mark Kappelhoff of the Justice Department, who will discuss, among other issues, hate crimes prosecutions and the work of the Community Relations Service to reduce tensions in communities. Thank you.
Thank you very much, Sabina. Let me begin with the discussion regarding hate speech and hate crimes. Many of the members of the committee raised that issue today and yesterday. While much of the hateful ideology espoused by extremist groups are protected under the First Amendment of the United States Constitution, we do in fact prosecute when hateful expression turns into what's referred to as a true threat of violence. I know this firsthand because I've actually prosecuted those cases. This also would include threats via the internet, and Mr. Coote raised that today. I also noted yesterday in my opening remarks that the enactment of the new Hate Crimes Prevention Act greatly expanded the federal government's ability to prosecute hate crime cases. And I'd like to note that that law became a reality largely because of many members in this room today, part of the civil society who pushed for that law for nearly a decade and a half. And in 2009, President Obama signed that into law. This is an important new law for hate crimes enforcement in the United States for several reasons. One, it expands our ability to prosecute hate crimes. Two, it enhances our enforcement efforts and allows us to collaborate more fully between federal, state, and local partners. We train together and we prosecute the cases together. And finally, it empowers the United States to prevent hate crimes. We can't prosecute our way out of these problems. Prevention is critically important. And through the Community Relations Service at the Department of Justice, known as the nation's peacemaker, they conduct coordination and outreach to build trust among different ethnic groups and racial groups to break down stereotypes and increase dialogue among those communities. Now, with regard to Madam Crickley's question regarding efforts to collect hate crimes data, we have been collecting hate crime data since 1990, and I'm happy to report to you that we are now for the first time in the United States collecting data based on a person's gender, gender identity, sexual orientation, as well as crimes committed by or targeting juveniles. This data will be released later this year when the annual Hate Crimes Statistics Act is published. In addition, in January of this coming year of 2015, the FBI will add a number of categories in its tracking of hate crimes. They will add offenses committed against Sikh, Hindu, and Arab individuals. As these efforts demonstrate, the United States is fully committed to stamping out hate violence in all its invidious forms. Now let me turn to an incident many members referenced in Ferguson, Missouri. in the United States. As many of you noted, there was a shooting last Saturday in Ferguson, Missouri, and I'd like to say on behalf of the Department of Justice, I'd like to express my deepest condolences to Michael Brown's family and to the community of Ferguson, Missouri. I can let the committee members know and the members of civil society who are present here today that at the request of the local authorities and at the direction of the Attorney General Holder, the Department of Justice has opened a concurrent civil rights investigation into this matter, in addition to the ongoing investigation by the local authorities into the shooting death of Michael Brown. Our pledge to the community is that we will conduct a thorough and complete investigation of this matter. I'd also like to respond to Madam Hueto's comment earlier regarding the Trayvon Martin matter. And I know Sabrina Fulton and Javaris Fulton are here today, and I had the pleasure to meet them 2 days ago. And that matter, the shooting of Trayvon Martin, is under investigation by the federal authorities. Let me turn to the issue regarding consent decrees and settlement agreements. Where we find discrimination in the areas of employment, housing, education, policing, and prisons, the Department of Justice oftentimes brings actions to achieve systemic reforms that result in consent decrees approved by a judge and enforceable in federal court. These provide clear roadmaps for reform, and each of these agreements is closely tailored to the problems identified during our investigation. We also meet extensively with community members to solicit input on potential reforms. Now, to ensure that these systemic reforms are meaningful and outlive the agreements, we increasingly include outcome measures to help determine constitutional compliance, as well as to ensure transparency, community engagement, and independent oversight of the agency. For example, our police reform efforts, we have entered 14 groundbreaking settlements in the last 5 years that are urging systemic reform of police departments. Several members raised issues regarding voting rights. In the United States, the right to vote is of fundamental importance to our democracy. The United States is committed fully to ensuring that each citizen can cast a ballot free from impermissible discrimination. While we too were disappointed by the Shelby County decision, it eliminated one of our most effective tools to combat discrimination voting. The United States is committed to using all of our remaining tools under federal law to address discrimination in voting. These include Section 2 of the Voting Rights Act, which allows the Department of Justice to challenge practices that limit voting rights on the basis of race, either intentionally or in results. In this regard, we filed 3 legal challenges in Texas and North Carolina, asking the courts in each case to subject the state to preclearance. And in Texas, we challenged the 2011 Texas House Redistricting Plan and voter ID requirement. In North Carolina, we are challenging changes to early voting, same-day registration, provisional ballots, and voter ID. We've also filed briefs challenging restrictive voting laws in Ohio, voter ID in Wisconsin. And we also stand ready to work with members of Congress from both sides of the aisle as they seek to fill the legislative void left by the Supreme Court's decision in Shelby. And the Attorney General has also called on state leaders and elected officials to enact reforms to restore voting rights to those who have paid their debt to society. Let me now turn to police misconduct. Unconstitutional policing practices are ineffective, and they undermine the public's confidence in law enforcement. Where there are problems such as excessive force, racial profiling, the Department of Justice can act in 2 ways. In one way, we can bring a criminal action against an individual police officer, and secondly, we can bring a civil enforcement action to address systemic problems and catalyze meaningful reform. We have prosecuted over 300 individual officers for misconduct over the last 5 years. And as I mentioned before, we have reached new milestones in our civil police reform efforts, including 14 groundbreaking settlement agreements. Through this systemic work and aggressive criminal prosecutions, the United States will continue to work toward eliminating discrimination and abuse in law enforcement, consistent with the U.S. Constitution and our obligations under this convention. Now I'd like to turn to my distinguished colleague and friend, the U.S. Attorney from the Eastern District of New York, Loretta Lynch.
Thank you, Mark, and good morning, members of the committee, members of civil society, ladies and gentlemen. I will be discussing several issues, but I'll begin with the various questions that have been raised about the interaction of the minority community with law enforcement at several stages of the criminal justice system. Let me begin by reiterating that the United States is committed to ensuring that the civil rights and civil liberties of all communities are not compromised by law enforcement carrying out its public safety and national security mission. Now, with regards to racial profiling, it is universally recognized throughout the United States by all good law enforcement officers that racial profiling is an ineffective tool. There have been questions raised about the data and how we collect that on interactions between the public and the police. The Department of Justice Bureau of Justice Statistics does indeed capture data on the public's interaction with the police. Then this data can be used to analyze patterns of profiling as well as provide other information about those interactions. Now, as you heard from my colleague Mark Kappelhoff, where the United States finds systemic abuses of power, we take legal action to change those policies and monitor those police departments. And as you've heard, there are over a dozen police settlements currently in effect. But a deeper issue exists, as has been raised here. By the time we take that action, much damage has already been done. Going forward, how do we restore the police-community relationship, which is essential for safe and effective policing? The Department of Justice is funding a new initiative, the National Center for Building Community Trust and Justice. This center will work with community organizations as well as law enforcement organizations on a broad range of ideas that impact community relations and trust, from stop and search to wrongful convictions. Studies sponsored by that center will expand our knowledge of the programs that effectively work to rebuild that trust. But the profiling issue also encompasses the concerns of our Arab, Muslim, and Sikh neighbors who feel unfairly targeted or surveilled after 9/11. And I can unequivocally state that the United States does not surveil any individual based solely on their race, ethnicity, or religion. That is a prohibited practice by law enforcement standards. But because of the strain that these issues have placed upon the Arab, Muslim, and Sikh community, the Department of Justice has met regularly with that community since 2003 to address issues of concern. And in addition, since 2010, the United States attorney community has been directly involved in outreach to the Arab, Muslim, and Sikh communities at the local level, working to rebuild trust as well as to provide protection from hate crimes, bullying, and all forms of discrimination. Members of the committee have also inquired about the Department of Justice guidance on the use of race by law enforcement, first promulgated in 2003. That document is being revised and is still currently under review. Certainly, we've had a number of questions about the overrepresentation of minorities in the criminal justice system. This is indeed an issue, particularly for African Americans in our country. A number of steps are being taken to deal with this serious issue. With the Smart on Crime initiative, the Attorney General last year directed all federal prosecutors to reserve the stringent mandatory minimum narcotic sentences and charges, as well as the repeat offender charges, for the most serious offenders. This will lift a burden from many minority defendants going forward. And we are also continuing to work with Congress on legislation to reform the mandatory minimum statutes themselves. The United States supported the Sentencing Commission's across-the-board reduction of the guidelines for all narcotics offenses, as well as retroactive application of that reduction, so those languishing under the older sentences can obtain relief. The Attorney General also chairs the Reentry Council, a multi-agency federal task force working on the myriad issues facing those rejoining society. With respect to the issue raised regarding the children of incarcerated parents, the Reentry Council agencies are currently putting in place strategies to ensure that children of incarcerated parents maintain the chances for success that all children should have, and that they are not negatively impacted by their parents' incarceration. The Departments of Health and Human Service and the Bureau of Prisons are working on a toolkit to better prepare child welfare officials as well as prison officials to help incarcerated parents maintain the bonds with their children, as well as may help the children maintain the connection with those parents. This is an important issue and an ongoing one. And I will add, it is also one that has been greatly informed by the NGO community, particularly the various civil society groups containing children of incarcerated parents, who've been very helpful in this debate. There have been a number of questions raised about the United States imposition of the death penalty. Let me let you know that the Department of Justice has worked very hard to establish individualized review in each case, with demographic information not included in the substantive review, so as to remove any issues of ethnic identity regarding either defendant or victim. That data is kept, but it is kept separately by those not working on the cases. There is also an exhaustive system of due process at the federal level, including two criminal defense attorneys, one of whom must have death penalty experience, and a robust pretrial motion and appellate process. Regarding the issue that's been raised about minority women as the victims of crime, in general, the Violence Against Women Act, which has been in place since 1994 and was most recently reauthorized, provides services both directly to victims as well as financial services to law enforcement agencies to both strengthen the victims of crime's ability to gain access to the courts, to treatment, to help regarding custody issues, as well as to help local law enforcement officials deal with these difficult and sensitive issues involving sexual violence and domestic violence. This is an area that also has been greatly influenced by the NGO community, and we thank them for their assistance. This committee has also raised questions not just about minorities' interactions with law enforcement, but with other citizens, with questions about state laws concerning stand your ground laws, as well as gun violence in the minority community. The Attorney General has stated that localities that have these stand your ground laws have an obligation to review them to ensure they do not go further than permitting legal defenses for deadly force where there is no safe retreat. Other entities are reviewing these laws as well, including the U.S. Commission on Civil Rights, the American Bar Association, and the Senate Judiciary Committee on Constitution, Civil Rights, and Human Rights. Regarding the issue of gun violence, definitely a serious problem in the U.S., particularly in communities of color. The President has been unwavering in his call for new gun legislation that would protect all Americans. But in the absence of such legislation, he has signed executive actions designed to improve gun safety, which are being utilized by law enforcement today. Regarding questions concerning civil access to justice, we note that the Legal Services Corporation has received increased funding for this year by 7%, and more has been requested for next year. In addition, through the Access to Justice Initiative, the U.S. is working to help expand civil legal aid representation in a myriad of areas, including housing and the like. Questions have been raised about the criminal charges faced by those coming across U.S. borders without documentation. We are aware that this is a very difficult issue, as we strive to balance the protection of our borders with individual rights. But let me assure you that defendants who are placed in the Operation Streamline program are afforded the full panoply of due process, from counsel to a hearing in open court to the right to trial and the right to an appeal. I now turn the microphone over to my esteemed colleague Dustin McDaniel, the Attorney General of the State of Arkansas.
It's a privilege to be with you and to address some of these questions from the perspective of state governments. Mr. Amir yesterday asked about indirect discrimination and protections that could be afforded beyond that which is allowed in federal law. And we believe that the states are uniquely situated to protect minorities in the marketplace and all who are unfairly treated within the marketplace. Attorneys General of the states have evolved into the state's chief consumer advocates. This is especially true over the last 30 to 40 years as Deceptive Trade Practices Acts have been passed in the given states, empowering attorneys general to protect the rights of those consumers who have been targeted by deceptive actors. Minorities are often targeted in credit scams, predatory lending, installment contracts, etc. The law protects all consumers, but by definition, the groups who are targeted disproportionately, regardless of their race or ethnicity, but those who are often unsophisticated in given transactions, require and deserve targeted protections. I discussed yesterday the mortgage fraud settlement, which was a great accomplishment by the states and the Department of Justice and the Department of Housing and Urban Development. Minorities were specifically impacted by the effort to expand subprime loans for the purpose of bundling the debt and reselling them for a profit. Minority borrowers were 70% more likely to lose their homes to foreclosure than non-minority borrowers, and the efforts to provide renegotiation of principal as well as distribution of the funds recovered in the settlement have benefited minority borrowers more than any other demographic. Also, questions were raised regarding juvenile sentencing. The United States Supreme Court is recognizing the need to acknowledge the unique nature of juvenile offenders. The trend of the court is absolutely to extend ever greater protections to juvenile offenders in the United States. In 2005, in Roper v. Simmons, the court abolished any death penalties for juvenile offenders, regardless of the offense. In 2010, life without parole for non-capital offenses was banned in Graham v. Florida. And in 2012, in Miller v. Alabama, and the lesser known and less cited, mercifully, case of Jackson v. Arkansas, the Supreme Court invalidated life without parole as a mandatory sentence even in capital offenses. In Arkansas, juveniles may be tried as adults, but only in the most severe cases, only under rare circumstances, and in every case the juvenile may petition to transfer out of adult court. States with mandatory or strict standards of trying juveniles as adults are increasingly skeptical of such policies, and they are being reviewed by legislatures and attorneys general nationwide. We acknowledge that there is further work to be done by the states with regard to serious juvenile offenders to ensure that the mandates of our Constitution and the intent of this convention are met. We recognize that the law is evolving towards more protections for juvenile criminal offenders, and we expect the courts and the states to continue on that path. It's now my privilege to recognize Catherine Lehman, the Assistant Secretary for Civil Rights at the Department of Education.
Thank you. I want to start by responding to the Chair's question about how we are responding to the Equity and Excellence Commission report, because that animates so much of the work that we do, and I'm proud that we're able to do that in partnership with many of the civil society organizations who are here with us today. It's been just an incredible part of our work. Most recently, the President's budget included a $300 million program that is focused specifically on responding to the Equity and Excellence Commission report, and it has four main levers. One is school funding, another is teacher equity, Another is access to high rigor coursework. And the final is school discipline reform. We would be thrilled to be able to use the grant making lever to be able to respond in this way to the Equity and Excellence Commission report's needs. In addition, we have active enforcement priorities in each of these areas. I shared yesterday a story about a recent school discipline resolution agreement. I'd like to share with you two stories about college and career readiness resolutions that we've recently entered into. One was just last fall in the state of Alabama. It's a school district that operates 4 high schools, one of which is overwhelmingly attended by black students. The other 3 are overwhelmingly attended by white students. The black high school had never, until 3 years ago, offered a single advanced placement course, which are our highest rigor courses in high school. And when they offered their first one 3 years ago, they did it without a teacher. It was online only. The principal at that high school said that he thought his students, the black students, would not be able to access high rigor courses, and instead they needed remedial education. I am so pleased that now that high school offers the full panoply of high rigor courses that the other high schools also offer. I am even more pleased that the district, in partnership with us, has engaged a consultant to go back to kindergarten to analyze what are the steps that need to be taken to be able to prepare students to succeed in high rigor courses by the time they will take them in high school. I'm thrilled about that resolution. Even more recently, just last week, we finalized a resolution with the California School District related to equal access to gifted and talented education opportunities. And Mr. Chairperson, you asked whether the disparate impact standard applies in areas such as education. It does. The United States Supreme Court has determined that private litigants cannot use the disparate impact standard in court, but that leaves to the muscular arm of the United States government to use the disparate impact standard, and I am delighted to be that muscular arm. So in California, we just last week entered into a resolution agreement with the district that had a disparate impact on its students' access to gifted and talented education. That is over. They are working with us now to deliver equal access to those courses for all of their students, which I am thrilled about. We also announced recently a new educator equity initiative that is nationwide. A part of that initiative will be to call in plans from each of the states about what they will do to better distribute teachers on an equal basis to the students who need them the most. We also are creating technical equity assistance centers who will use millions of dollars to share best practices with school districts around the country about how best to deliver our highest quality educators to the students who most need them. We also recently have announced teacher preparation regulations that will better evaluate how our schools are preparing our teachers to teach the actual students they will teach and what successes they will have, so we can see our teachers better prepared to enter the profession and deliver for the students who need them. Several of you, the chair, Mr. Diacono, Mr. Lindgren, Mr. Wong, and Mr. Yoon, have asked questions about how we're responding to the Supreme Court's decision in Schuette on affirmative action. I want to say that we have repeatedly issued guidance about the ways that this administration actively supports racial diversity in our colleges and universities and in our K-12, the elementary and secondary education. In 2011, we rescinded guidance that the government had issued in 2008, explaining the ways to achieve voluntary desegregation efforts. In 2011, we issued 2 documents, one focused on elementary and secondary education, the other focused on colleges and universities, that specifically called out the ways that our colleges and universities and our elementary and secondary schools may voluntarily use race to be able to achieve racial diversity in schools. We were very proud to be able to release that. And then in 2013, we issued new guidance after the United States Supreme Court issued the Fisher decision that reaffirmed that that guidance still obtains and that there are methods that can be used to be able to achieve racial diversity in our schools, and that we support those efforts. Most recently, after the Schuette decision came down, we issued guidance last May that was focused specifically on the continued vitality and viability of achieving racial diversity in schools. That guidance directs all of our states that when they are not in the 8 states that have outlawed affirmative action as a state matter, the guidance that we had previously issued continues to obtain, and that we fully expect that they will continue to achieve racial diversity. We also directed those states, those education community members in the 8 states where that's no longer true to turn to their attorneys general for guidance about what they can do. And we're pleased to be able to work in partnership with those attorneys general to deliver educational equality for all students. There are still options available, including in those states, for being able to deliver racial diversity in colleges and in universities and in K-12 schools for the students who need them. And we fully expect to be able to work in those communities to be able to deliver equal educational opportunities for those schools. Mr. Lindgren asked if we have quotas. No, we do not. Just to be very clear. Mr. Wong, you mentioned that there was a California State Senate proposal that affects this area. That proposal was actually about repealing the ban on affirmative action that is now true and was at that time true in California. Some, certainly not all, of the Asian Pacific American community organizations in the state raised a set of concerns about the continued access for Asian Pacific American students to colleges and universities if the affirmative action ban were repealed. The California State Senate, as a result of those concerns, has tabled that. That proposal is no longer pending, and it is not a continued option at the moment in California. Then several of you, Mr. Kemmel, Mr. Lindgren, and Ms. Hueto, asked questions about school closures, in particular about school closures in Chicago. I want you to know that our view is that every time a school is closed, that raises very serious concerns for the community, very serious concerns that we need to be taking into account. We have 36 pending investigations around the country, including in Chicago, related to the school closure question. We investigate that question under both the intentional discrimination and the disparate impact framework so that we evaluate whether there is an intent to discriminate when a school is closed and whether under the totality of the circumstances, the educational opportunity that will be delivered to the students who would have attended those schools is substantially similar, including on the dimensions of access to disability education, access to high-quality teachers, and the total quality of schooling. So I look forward to being able to resolve those investigations, and we take those concerns extremely seriously in our department. Ms. Hueto, you also asked for data about preschool access, and I'm pleased to tell you that my office collects data every other year about the equity health of our K-12 schools, and so I can share with you the data that you asked for. 60% of the 16,500 school districts in the United States offer public preschool. Of those districts, 18% of the students are Black, 29% of the students are Latino, 4% of the students are Asian, 43% of the students are white, 2% of the students are American Indian, Alaska Native, 1% of the students are Native Hawaiian or other Pacific Islander, and 4% of the students self-identify as 2 or more races. There was a question from the chair about national origin discrimination, but I am well over my time, so I will just say I would love to talk to you about it another time. Mr. Diacono, I wanted to respond to your concern about the high volume of complaints that we have received. I believe that high volume speaks to the quality of the work that we are delivering and the community's confidence in us as being able to use the muscular arm that we have to be able to deliver the results that they need, especially because on racial considerations, in particular, they cannot, for disparate impact purposes, turn to the courts themselves. They need to come to us. We're glad they come to us, and we hope to earn their trust and warrant the high volume of the complaints that we have been receiving so that we can deliver the justice that Ms. January Bardell mentioned for all the students who need us. With that, I'll turn to the ambassador.
Thank you. I will address 3 of the issues raised that are specific to Indigenous peoples, others on our delegation, including Deputy Assistant Secretary Larry Roberts, will add to both those issues and address other matters raised. Committee member Avtamatov raised the issue of the alleged loss of tribal rights by individual Indigenous persons. I believe there is a misapprehension of the system in the United States regarding tribal citizenship or membership that forms the basis of this query. Central to the federal-tribal relation in the United States is that tribes should, whenever possible, enact their own laws and policies and be governed by them. This is often referred to as tribal sovereignty, and it is a best practice and widely supported throughout tribal communities. This means the tribes should be the key decision makers on matters that impact their community, and further, that the United States will have a nation-to-nation relationship with tribal governments. The paradigm, I will note, is in synchronicity with the Declaration of the Rights of Indigenous Peoples. A central, critically important, and inherent power of the tribe as governing body is to decide who is and who is not a member or citizen. That is the way it should be. The rapporteur and other members have raised the important issue of federal acknowledgement or recognition of tribal governments. With federal acknowledgement comes the legal right of tribal nations to exercise inherent, statutorily recognized, and treaty-recognized powers. Not any conglomeration of individuals should be so recognized. Otherwise, it would water down those important tribal government rights and make them less meaningful. Accordingly, there is a need to have a robust, thorough, and fair process to determine which group of individuals are indeed a tribe under federal law. The process is handled as a general matter by the Department of Interior. We acknowledge that there have been legitimate concerns raised and issues raised with respect to the federal acknowledgement process. That is precisely why the Bureau of Indian Affairs is in the process of revamping the federal acknowledgement process to make it more fair, more transparent, and more streamlined. Deputy Assistant Secretary Roberts will speak in greater detail to this process. Finally, I want to talk about the violence against Indigenous women. At least to me personally, and I think I share the concern from my esteemed chair of this committee, it is one of the most important issues raised, and it is an intolerable problem. Let us be clear and not mince words. Violence against Indigenous women is a worldwide scourge. Every state should take affirmative steps to address it forcefully. We are no exception. Native women are more likely to be victims of violent crime than any other racial gender category. But there is a robust domestic dialogue about how to best address this matter. There are things that have been done so far. First, there was the enactment of the Tribal Law and Order Act, which provides additional tools to both federal and tribal law enforcement to address both violence and collect vital information, which will enable us to continue to develop best approaches. Then there is the watershed development of the Violence Against Women Act reauthorization. For the first time, the courts of tribal nations are empowered to criminally prosecute non-Indians who commit these heinous crimes. This is a critical development because statistics indicate that the majority of perpetrators are non-natives themselves. I realize there is, in the present law, an Alaska exception. The administration has taken the position that that Alaska exception should be revoked, and that key senators, including the senators from the state of Alaska, have agreed on the repeal of that provision. With respect to this important development on the violence against women, I would say that I don't think that there is any country in the world that has taken such a forward-leaning approach by providing jurisdiction to tribal nations. And further, that the approach follows the best practices of empowering Indigenous peoples themselves and their institutions to address challenges they face, here by recognizing the inherent criminal jurisdiction authority. There is no silver bullet, but we are resolved to address this continuing challenge. Thank you, and with that I will turn it over to Deputy Assistant Secretary Larry Roberts from the Bureau of Indian Affairs.
Thank you. Mr. Chairman, distinguished members of the committee, my name is Larry Roberts. I'm the Principal Deputy Assistant Secretary at the Department of Interior for Indian Affairs. Like Ambassador Harper, I am also an Indigenous member of this delegation. I'm a citizen of the Oneida Nation of Wisconsin. As a tribal citizen, I'm honored to work for President Obama, the only president that has met every year with tribal leaders, a president that established the White House Council on Native American Affairs, and a president that recently made a historic visit to the Standing Rock Indian Reservation. I want to begin by sharing with the committee that our North Star on tribal issues is self-governance and self-determination. We know that when we respect the sovereignty of tribes, good things happen. I would like to start with Mr. Amir's and Mr. Atanov's questions regarding the recognition of tribes. In 1978, the United States promulgated a process to recognize tribes. The process has been criticized by many as broken. Hearing this criticism, the department initiated an extensive process with both tribes and the public on potential reforms. Earlier this year, the Department of the Interior issued a proposed rule to reform the federal acknowledgement process. Changes under consideration would make the process more transparent, more efficient, more timely, and flexible, but yet maintaining the integrity of that process. With regard to Madam Crickley's questions about the Indian Child Welfare and the Indian Child Welfare Act, there is no more valuable resource for tribes than their children. The Indian Child Welfare Act is a vital statute to protect the integrity of tribes and the welfare of Indian children. Among the most important provisions of ICWA are those that confirm tribal jurisdiction over child custody proceedings. The United States strongly supports these provisions, which promote and encourage tribal self-governance, and the United States has defended tribal jurisdiction against numerous court challenges. With respect to concerns about potential bias in the public child welfare and private adoptive systems and non-compliance with the Act, federal, state, and tribal government monitoring for compliance with the Act is essential to assure that Indian families are afforded the access to adoption systems in keeping with the intent of the Indian Child Welfare Act. We are working hard to deal with these issues, and we are working closely with NGOs on mechanisms to foster compliance. Our guidelines have not been updated since the Act was passed into law, but we are now working to update those with the cooperation of NGOs. And in consultation with tribes, we are looking closely at whether the department can promulgate regulations to ensure greater compliance with the Act. This issue is of critical importance, and we will continue to work with tribes and states to ensure that Indian children receive the full protection of federal law. With regard to Mr. Amir's and Madam Crickley's and Mr. Kaloff's questions about boarding schools and Indian education and unemployment in Indian country, we acknowledge that there has been intergenerational harm caused by forced removal of children from their homes and placement in boarding schools with the express purpose to eradicate their language and culture. This ended in the 1960s, and today, under our policies of self-determination and self-governance, the majority of Bureau of Indian Education schools are run by tribes. President Obama has made it a priority to support tribal communities in improving the education of Native students. The President understands that the best solutions for Native American students come from those that know these students best, the tribes. On June 12th, my boss, Secretary of Interior Sally Jewell, issued an order that will redesign the Bureau of Indian Education from a direct provider of education into an innovative organization that will serve as a capacity builder and service provider to tribes with Bureau of Indian Education funded schools. Unemployment and poverty in Indian country is often generational. And as many members of the committee have it referenced yesterday, education is the key out of this cycle of poverty. With regard to Vice Chairman Amir's and Mr. Kaloff's questions about the loss of ancestral lands, I would like to acknowledge that the United States less than honorable history and take an opportunity to affirm that recovery and protecting tribal lands is a hallmark priority for this administration. We have set a goal of taking 500,000 acres of land into trust on behalf of Indian tribes. Thus far, this administration has acquired over 263,000 acres of land for tribes and processed more than 1,700 separate requests from those tribes to take these lands for tribal uses. The government has entered into landmark settlement with the late Eloise Cobell and individual Indians that establishes a $1.9 billion fund that will be used to purchase land interests and return those lands to tribal ownership. To date, this program has spent over $80 million and has returned the equivalent of over 245,000 acres to tribal ownership. With regard to Mr. Avtanamov's question concerning the Western Shoshone, The United States has completed the distribution of funds to settle the Western Shoshone claims based on a 2004 law that authorized distribution of $145 million to qualifying Western Shoshone individuals. And for a detailed history of this matter and the United States position, the United States would refer the committee to its 2007 report and accompanying Annex 2, as well as an update in its 2013 report. With regard to Mr. Amir's question regarding the respect for Indian treaties, we recognize, as Mr. Bosute mentioned yesterday, that Indian treaties are the supreme law of the land. We have affirmatively litigated to protect treaty reserved rights from coast to coast. On the West Coast, in litigation against the state of Washington, we prevailed in district court that the treaty right to fish includes that the state must maintain culverts to ensure fish passage. On the East Coast, we've initiated litigation against the state of Maine to protect reserved fishing rights for the Penobscot Indian Nation. With regard to Mr. Amir's and Mr. Murillo Martinez's and Mr. Kamal's question regarding free, prior informed consent and sacred sites, the United States has a robust and updated consultation procedures with its indigenous peoples, starting at the very highest levels with President Obama's commitment to engaging in a nation-to-nation relationship with federally recognized tribes. We've engaged in extensive consultations with tribes, and those consultations often lead to positive outcomes. I'd like to close with two important examples. First, the United States worked with the Bad River Band of Lake Superior, Chippewa to accommodate the request to issue a temporary closure so that the tribe could hold ceremonial activities in an area that is considered sacred by the tribe. The closure is in accordance with the 2008 law that allows for special closures to be issued for the privacy of tribal activities for traditional and cultural purposes. The United States, the Hopi tribe, and the Kaibab Band of Paiute Indians have been working together on the collaborative management of sacred places since the 1990s. Through consultation, it became evident that the management of natural waters as sacred sites is very important to the tribes. Spring restoration is now one of the 4 priorities of the Forest Management Plan, and most recently, Hopi elders, along with the United States and Hopi youth, spent a week together working to restore the hydrological function and vegetation on 2 springs of importance to the tribes. Tribal elders share traditional ecological knowledge and techniques to be integrated into future federal spring management protocols. I would now like to turn it over to Dr. Gracia from the Department of Health and Human Services.
Thank you. Good afternoon. My name is Nadine Gracia, and I'm the Deputy Assistant Secretary for Minority Health at the U.S. Department of Health and Human Services, or HHS. I serve as the Principal Advisor on Minority Health to the Secretary, and I coordinate strategic initiatives on health disparities and health equity. The U.S. government is committed to eliminating health disparities and achieving health equity across the lifespan, so that everyone has the opportunity to reach their full potential for health. The U.S. government's framework to reduce health disparities includes 3 key components. First, the Affordable Care Act, which is, in the words of Mrs. January Bardil, truly a transformative law. You will hear more about the healthcare law from my colleague, Kara James, and how it is truly transforming public health and healthcare in the United States. Second, our government has established a national action plan to reduce racial and ethnic health disparities. It is the most comprehensive federal commitment to reducing health disparities in our nation. And you will hear later from Mayor Bell regarding a program that he is receiving funding from our government that addresses a key area in that disparities action plan that focuses on research as well as workforce. And third, recognizing the importance of collaboration between the federal government, state and local governments, and civil society to effectively address health disparities and advance health equity. The National Partnership for Action to End Health Disparities was established as a nationwide, community-driven movement towards combating health disparities using a social determinants of health approach, addressing factors such as poverty, education, and access to services. Collectively, these efforts are addressing a variety of health and health care issues that disproportionately impact racial, and ethnic minority populations. I would like to respond to a few areas in particular. In the area of women's health, the Affordable Care Act promotes and protects women's health and makes it a priority by expanding access to preventive care. The issue of violence against women has been discussed, and as Ambassador Harper has stated, it is truly a serious and important issue. It is an important issue to me as well personally. I'm a pediatrician by training, and during my medical training, I took special coursework to be trained as a domestic violence medical advocate, so that when women reported to the emergency department, I could assist them in providing access to services. The issue of violence against women is one that we take very seriously. We provide training and technical assistance to health professionals and domestic violence, sexual assault programs to address and prevent the chronic health issues and injuries that are associated with exposure to violence. Also, the Affordable Care Act provides that domestic violence screening and counseling services are among the preventive health services and benefits that are covered now under health insurance market plans under the Affordable Care Act. Thirdly, the White House Task Force to Protect Students from Sexual Assault was established earlier this year to strengthen federal enforcement efforts and provide schools with additional tools to prevent sexual assault on their campuses. Specifically regarding violence against Native American women, our government is funding a domestic violence prevention initiative and has launched a tribal forensic healthcare website to train healthcare providers on domestic and sexual violence. In other areas of health concerning the Native American population, we have programs and a national suicide prevention plan aimed at reducing suicides among the Native American population. My colleagues from the Department of the Interior spoke about the Indian Child Welfare Act. Although HHS does not have jurisdiction to enforce compliance with this law, we are taking steps in a number of areas to enhance awareness and compliance. As part of a state's 5-year child and family services plan used to request and coordinate federal child welfare funding, states must describe the measures they are taking or will take to comply with the Indian Child Welfare Act. In the area of mental health, our government acknowledges the importance of mental health as integral to our overall health. The Affordable Care Act provides one of the largest expansions of mental health and substance use disorder coverage in a generation by requiring that health insurance plans in the health insurance marketplace cover mental health and substance use disorder services. The government also actively works toward promoting prevention and wellness in mental health in areas such as youth violence prevention, trauma and trauma-informed care, mental health services for children, and suicide prevention. Questions were raised with regards to medication use. The U.S. government is committed to protecting public health by assuring the safety, effectiveness, quality, security of human drugs, vaccines, and biological products, as well as medical devices, and supporting the appropriate use of psychotropic medications to treat mental, emotional, and behavioral disorders is one piece of this work. Finally, to briefly touch on Mr. Huang's question about sex-selective abortions. We understand that the American Civil Liberties Union has brought a lawsuit against Arizona's law banning sex-selective and race-selective abortions, and that the case is pending before an appellate court. I'd now like to turn it over to my colleague, Dr. James.
Thank you, and good afternoon. My name is Kara James, and I'm the Director of the Office of Minority Health at the Centers for Medicare and Medicaid Services in the Department of Health and Human Services, or HHS, and I'm honored to be here today to speak before such a distinguished body. I'm going to address some of the questions mentioned by Mrs. Crickley and Mr. Kamal related to the Affordable Care Act, access to health care for immigrants, and data collection and disaggregation. As Dr. Gracia mentioned, and in the words of Madam January Bardell, the Affordable Care Act, or the ACA, is truly transformative. It is the most significant health legislation to be enacted in nearly 50 years that addresses health disparities. It seeks to provide millions of Americans with access to affordable health coverage. It also seeks to improve the quality of care provided through our healthcare system, and it includes provisions specifically related to addressing health disparities, including the Indian Healthcare Improvement Act. The ACA expands coverage by expanding employer-sponsored coverage, expanding Medicaid, the program for low-income individuals, and creating health insurance marketplaces for people without access to the aforementioned program. The law also strengthens Medicare, the program for the elderly and disabled. As Madam Quickly noted, states have a choice as to whether they will expand Medicaid, and we are pleased that 26 states have opted to do so. Other states still have that opportunity to expand this vital program, and we continue to hope that more of them will do so in the near future. As a result of the Affordable Care Act, millions of Americans have enrolled in coverage, and more continue to do so every day. A question came up yesterday with regards to access to care for our immigrant population. As Mrs. Crickley also noted, her concern for access to care. And the U.S. is committed to ensuring that all persons receive the treatment and protections to which they are entitled under our Constitution and laws. By law, all persons in the U.S., including undocumented individuals, are entitled to emergency health services. Lawfully present immigrants are subject to a 5-year waiting period before they qualify for Medicaid. However, states have the option to remove the waiting period for low-income pregnant women and immigrant children, and 29 states and the District of Columbia, as well as the Northern Mariana Islands, have done so. There are also a number of other healthcare resources available for immigrants in the U.S. For example, regardless of how long they've been there, lawfully present individuals may purchase coverage through the health insurance marketplace. Immigrants also have access to the vast network of community health centers throughout the U.S. These centers have a long-standing commitment to meeting the needs of underserved communities and serve more than 20 million people a year, including many individuals who are racial and ethnic minorities, as well as individuals who are not immigrants. The Affordable Care Act increased funding to these vital centers to support ongoing health center operations, create new health centers in medically underserved areas, and to expand preventive services and primary care, including oral and behavioral health. As Mr. Coliff noted about his concerns regarding the health care of indigenous populations, the Indian Healthcare Improvement Act strengthened the Indian Health Service, expanded the workforce, and as well expanded access to third-party funding to free up dollars for the Indian Health Service. Finally, on data disaggregation, the Affordable Care Act includes a number of provisions that directly address health disparities, including a provision requiring the development of standards to increase data collection and reporting related to race, ethnicity, primary language, sex, and disability. As Ms. Quickly noted, having disaggregated data is crucial to monitoring disparities. We've included these standards in the marketplace application, and as a result, we know that among those who reported their race, nearly 4 in 10 people who enrolled in coverage through the marketplace are racial and ethnic minorities. Again, the ACA is truly transformative in terms of addressing disparities, and while the law is not perfect, we continue to work to improve it as we implement it to ensure that all Americans have access to quality, affordable health care. It is now my pleasure to turn it to my colleague, the Honorable William Bell, the Mayor of Birmingham, Alabama. Thank you.
Thank you, Dr. James. Madam Quickly, on yesterday you rightly raised the issue concerning women's health and access to health care as it relates to their reproductive rights and other areas. As has been pointed out by Dr. Gracia as well as Dr. James, the Department of Human Services, Health and Human Services is actively working to assure that all citizens, regardless of their station in life, receive adequate health care. To that extent, in Birmingham, we have had a program funded called the Minority Health and Health Disparity Research Center that is funded by the National Institute of Minority Health and Health Disparities. That center is designed to examine and eliminate barriers to health care for minorities of all stripes. It is designed to eliminate physical, social, and cultural barriers to health care and put in place those programs that will enhance the ability to deliver healthcare services to those individuals. To Madam Hojeda, you raised the issue concerning minority males in incarceration and programs of that nature. The President has called for a program called My Brother's Keepers, of which the African American Mayors Association, of which I'm the president, has totally endorsed and support and taking an active role in working with young men of color, and also a reentry program that has been established in the city of Birmingham called the Dannon Project that is funded by the Department of Labor. That reentry program not only helps young men who are coming out of prison to find work and ways to reintegrate themselves back into society, but it also works with those young men and women, I might add, to restore their rights that were taken away at the time of their incarceration. To Madam January Bardell, let me say that I'm a member of the U.S. Conference of Mayors, but my history and support of international efforts go back many, many years. In 1985, I became a member of the Americans for South Africa, that was organized by a gentleman from South Africa that called upon the U.S. to not do business with companies that were supporting of the apartheid government in South Africa. We worked very diligently to do that. In 1993, when Nelson Mandela came to America, I had the opportunity to meet him, and he stated at that time that one of the things that encouraged him during his 26 years of incarceration was that if change could come to Birmingham and the American South, then change could come to South Africa. I'm grateful to see you present today representing your country in an effort to make sure that all people are treated fairly and that we implement those programs within the U.S. to assure that. Let me say I will continue to work for that goal as mayor of my city, but as president of the African American Mayors Association and as the chairman of the COCARS, which stands for the Coalition of Cities Against Racism, which is an international movement that is sponsored by the UN and UNESCO to assure that we remove all barriers within local governments that would suppress anyone regardless of their race, creed, or religion. Thank you. I now turn it over to Mr. Brian Green, Deputy Secretary of Housing and Urban Development.
Thank you, Mayor Bell. My name is Brian Green. I am the General Deputy Assistant Secretary for Fair Housing and Equal Opportunity at the United States Department of Housing and Urban Development. Mr. Chairman, distinguished members of the committee, I welcome the opportunity to share how our government is combating housing discrimination, residential segregation, and homelessness in the United States. Almost all committee members voiced concern about how racial minorities are disproportionately affected by school segregation, health problems, neighborhood pollution, and crime. Often, housing segregation is the underlying common denominator. Too often, life outcomes are determined by neighborhood. The United States recognizes the historic role our government has played in creating and reinforcing segregated housing patterns in America. We take seriously our obligation to reverse this legacy as mandated by the Fair Housing Act since 1968. Since our last appearance before this committee, the United States has proposed the Affirmatively Furthering Fair Housing Regulation, which clarifies the obligation of federally funded states and local communities to take positive actions to address segregation. We also enforce our current authority when such communities take negative actions that perpetuate segregation, as we did in St. Bernard Parish, Louisiana, and in Sussex County, Delaware, where we alleged that opposition to affordable housing effectively excluded racial minorities from some communities. In response to a question from Mr. Diacono, we also partner with and financially assist approximately 100 state and local governments, those who have adopted and enforce their own fair housing laws to meet that strong federal standard. Turning to the question of disparate impact, for decades, the United States has utilized the disparate impact standard in housing cases. Last year, the U.S. government issued a regulation to formalize the disparate impact legal standard under the Fair Housing Act. In response to Mr. Amir's interest in recent cases, I highlight two. The first responds to Madam January Bardill's question about discriminatory lending. We used disparate impact to bring the case United States versus Countrywide Financial Corporation, which led to a record $335 million settlement for African American and Hispanic borrowers who were allegedly steered to subprime loans and charged higher rates and fees than similarly situated white borrowers. And then, for another example of how the U.S. government is arguing disparate impact in housing cases, we need look no farther than my colleague, the United States Attorney Loretta Lynch, who brought and successfully settled a recent disparate impact case in New York in the case of the United States versus the town of Oyster Bay, where residency preferences in an affordable housing program allegedly had the effect of excluding African Americans from that program. I want to respond more fully to Madam January Bardill's important questions on discriminatory lending practices. Several federal agencies are working together to address discriminatory lending practices, including cases involving mortgage fraud targeted to African American and Hispanic lenders. In addition to the Countrywide case that I just mentioned, my office recently settled a case with the lender Mortgageit, now part of Deutsche Bank, providing $12.1 million in relief to African American and Hispanic borrowers who were allegedly denied loans at higher rates or charged more in rates and fees than similarly situated white borrowers. The United States also settled a case with Wells Fargo Bank for $234 million to address allegations that the bank steered minority wholesale borrowers and retail borrowers into subprime mortgages in a discriminatory manner. So the U.S. is committed to continued enforcement against lenders that engage in discriminatory lending practices. In response to Madam Crickley's request for disaggregated data on homelessness, the Department of Housing and Urban Development collects such data disaggregated by race, ethnicity, gender, age, family status, and veteran status. We have also specifically designed programs to assist veterans, families, and the chronically homeless. The United States has an ambitious goal of eliminating all of these forms of homelessness by the year 2000. And we also have this committee and civil society to thank for raising the profile of the criminalization of homelessness in our country. Your concerns have given the issue urgency and priority and have spurred a productive collaboration among nonprofit organizations, federal agencies, local governments, and will continue that work this summer through some of the efforts we are engaged in. These are all the areas in which the U.S. still has much work to do, but I appreciate the opportunity to share some of the important steps we have taken since our last appearance here. And continued progress in addressing housing discrimination is integral to the achievement of all of our other human rights goals. Now, I would like to turn to my colleague, Ms. Au, from the Department of Homeland Security.
Thank you. Mr. Chairperson, distinguished members of the committee, my name is Elena Au. I'm the Principal Director for Immigration Policy at the Department of Homeland Security, and it is my honor to appear before you today. With respect to Mr. Amir's, Mr. Diakonu's, and Madame Crickley's concerns about access to counsel in civil proceedings, particularly immigration proceedings, I provide the following information. To facilitate access to counsel for individuals in immigration proceedings, the U.S. government provides a list of free legal service providers and works closely with nonprofit organizations to ensure that individuals are made aware of their rights and remedies and what to expect in the proceeding. Immigration judges are also instructed to assist pro se individuals to the greatest extent possible in such proceedings, including ensuring that such respondents are informed of potential forms of relief from deportation or removal. The U.S. government is particularly concerned with vulnerable populations. In April 2013, the Department of Homeland Security, in partnership with the Department of Justice, issued a policy providing new procedural protections, including qualified representatives for individuals that are mentally incompetent. With respect to the issue of unaccompanied children, which Mr. Amir and Mr. Koloff specifically raised, several steps have been taken with regard to legal representation for this particular vulnerable population. The government works closely with non-governmental organizations to identify children in need of legal assistance and facilitate pro bono legal services. Caregivers of unaccompanied children are also provided with legal information. On June 6, 2014, a federal Justice AmeriCorps program was created aimed at paying 100 lawyers and paralegals to represent unaccompanied minors in immigration proceedings. In addition, the U.S. government has established juvenile dockets in all immigration courts, issued guidance to immigration judges on facilitating pro bono representation, and offered training to immigration judges in handling cases involving children, such as child-sensitive questioning. Further, on the issue of unaccompanied children, the recent and dramatic rise in irregular migration across the border from Honduras, El Salvador, and Guatemala presents a major challenge to the U.S. Because so many of those crossing our border are children, there is also a humanitarian dimension to this problem, which the United States is bound and determined to respect. As Americans, we have and will continue to adhere to domestic and international law, due processes, and the basic principles of charity, decency, and fairness as we enforce our immigration laws. To address this humanitarian crisis, the U.S. government has instituted a multifaceted approach, which includes increasing capacity and resources to effectively and appropriately manage this vulnerable population, providing Spanish-speaking case management staff, conducting public health screening, working together with voluntary and faith-based organizations towards sensible solutions, intensifying public affairs campaigns to dissuade individuals from traveling, dismantling smuggling organizations who promote the traveling and promote misinformation, and working closely with the governments of Guatemala, El Salvador, and Honduras in the spirit of shared responsibility in an effort to address root causes. As a result, the number of unaccompanied children encountered along the U.S. southern border has decreased in July. However, much work remains to be done. That said, operational and policy changes are no substitute for comprehensive immigration reform, which is the best way to provide a lasting solution to uphold our proud tradition as a nation of laws and a land of immigrants. As such, the United States is working toward that goal. And with that, I have the pleasure of turning the dialogue to my colleague, Ms. Venture.
Good afternoon, Mr. Chairperson, distinguished members of the committee, of the convention, members of civil society. My name is Veronica Venture. I'm the Deputy Officer for Civil Rights and Civil Liberties at the Department of Homeland Security. To address Mr. Amir's question about detention, particularly of asylum seekers, the United States government is focused on smart, effective immigration enforcement that prioritizes resources to promote border security and to identify and remove those who pose a threat to public safety and national security. At the same time, the United States works hard to ensure that undocumented individuals are treated humanely, consistent with U.S. laws and applicable international obligations. Bear in mind that the vast majority of people that come through immigration proceedings are not detained. low-risk individuals who are not required by law to be detained are eligible for bond or placement in alternatives to detention programs. Those programs are included but not limited to monitoring through telephonic reporting, electronic monitoring, and home visits. So the President's budget in FY14 proposed a $2 million increase to alternatives to detention programs rather than to increase the beds in detention centers. There are several circumstances under which undocumented immigrants, including asylum seekers, may be detained, such as pending a determination of whether the individuals have credible fear or return to his or home country, or the purpose of obtaining and executing a removal order. One of the things that Mr. Amir had, or one of the council members had pointed to yesterday, was the amount of time spent in detention. The actual average length of stay in detention for those involved in proceedings is 47.3 days, not 111 days as quoted. The U.S. Immigration and Customs Enforcement Service employs a rigorous and multi-layered approach of monitoring and oversight to ensure that facilities comply with federal detention standards. The standards ensure that detainees have adequate access to medical care, legal resources, visitation, recreation, grievance processes, and other programs and privileges. To address Ms. Crickley's question regarding family detention, families who are detained can request bond hearings, and the Department of Justice is prioritizing those immigration cases in order to minimize the time families are spent in detention. There are family residential standards in place which guide the care and custody of nonviolent, non-criminal families housed in residential centers, pending the outcome of immigration proceedings. The standards were developed with input from medical, psychological, educational subject matter experts and various organizations, such as my office, the Office of Civil Rights and Civil Liberties, and many of the non-governmental organizations present today. With regard to Mr. Amir's question regarding the excessive use of force at the border, my department enforces strict standards of conduct for all of its employees and affiliates. We investigate any deaths resulting from use of force, and follow up with public complaints also talking about the abuses of use of force. The U.S. Customs Protection and Border Service continues to review and updates its use of force policies on a regular basis, and have had 3 comprehensive reviews of that policy in the past years. On May 30th, 2014, CBP released its complete use of force updated handbook, which is available on its public website for anyone to view. While the current statistics of overall percentage of cases that result in discipline or prosecution are unavailable, I do know that my office, the Office of Civil Rights and Civil Liberties, has opened 32 cases involving the use of force by CBP officers. Further, CBP electronically monitors all its uses of force by agents and officers, and this data is monitored by its supervisors as well as by my office on a continuous basis. Thank you for the opportunity to respond. I have other answers, but I cede my time to my colleague, Ms. Garralio, at Department of Labor.
The Office of the Solicitor. I'll start by addressing the child labor concerns that Mr. Murillo and Madam Crickley raised, in particular with regard to agriculture. The Fair Labor Standards Act of 1938, the U.S. law governing the employment of children in agriculture, is enforced equally for all children, regardless of race. In 2011, the Department of Labor proposed a rule under this law that would expand the list of agricultural occupations considered too hazardous for the employment of children under the age of 16. Under U.S. law, the department must consider the views of interested stakeholders and the U.S. public on any proposed rule. The department received over 10,000 comments, many from parents who own or operate farms who believed the rule would prevent their own children from working legally on the farms. Other commenters, including nearly 200 members of our U.S. Congress, were concerned that the rule would undermine the preparation of the next generation of American farmers and ranchers. In light of the thousands of comments expressing profound concerns, the department made the difficult decision of withdrawing the proposed rule based on a deep commitment to listening to the public's opinion about proposed regulations. Instead, the department affirmed its intention to promote the safety and health of children employed as farm workers and intensified its effort to combat unlawful child labor, including through targeted enforcement in low-wage industries, such as agriculture, where we have observed historical and persistent violations. Additionally, the Environmental Protection Agency recently proposed changes to its worker protection standard that will generally prohibit children under 16 years of age from handling pesticides. I will now turn to questions raised by Mr. Lahiri and Madam Creakley regarding our H-2B guest worker program. The Department of Labor enforces protections for these workers, and in 2012 published new regulations that would significantly strengthen these protections. However, the department is currently enjoined from enforcing these regulations as a result of ongoing litigation. The new regulations would require that employers disclose to workers the terms and conditions of employment and provide to the department copies of contracts with its recruiters. The department would also maintain a publicly available list of agents and recruiters, making the recruitment process more transparent to agencies, workers, and advocates. The department continues to enforce existing protections, including prohibiting employers from charging workers for recruitment costs or making deductions that bring workers' wages below the minimum wage required. Possible remedies for violations include employer debarment from the program. If the department suspects that human trafficking or other criminal activity is taking place at a worksite, it immediately refers the case to a criminal law enforcement agency. I'll now conclude with some comments responding to Ms. Creakley's concerns about undocumented workers. The U.S. is committed to ensuring that all persons in the U.S. receive the protections to which they are entitled under our Constitution and laws, including applicable international obligations. U.S. federal labor and employment laws generally apply to all workers, and the Department of Labor vigorously enforces labor and employment laws without regard to immigration status. Recognizing that we cannot always reach these workers, the Department of Labor has established formal partnerships with the embassies and consulates of 11 countries that are major countries of origin for migrant workers to the U.S. As a result of this program, thousands of migrants have been informed about their labor rights in the U.S. Thank you very much for the opportunity to address you. I'll now turn the floor to my esteemed colleague, Danny Gogol from the Environmental Protection Agency.
Mr. Chairperson, distinguished members of the committee and representatives of civil society, my name is Daniel Gogol, and I work at the U.S. Environmental Protection Agency, the EPA, and the Office of Environmental Justice, which coordinates the integration of environmental justice throughout the United States government. Environmental justice is the meaningful involvement and fair treatment of all people, regardless of race, color, national origin, or income, and the development, implementation, enforcement of environmental laws, regulations, and policies. Mr. Amir, Mr. Diakonu, Mr. Kamal, Mr. Kalof, and Madam Ohoulato, and I apologize for the mispronunciations. You asked questions regarding the U.S. government's work to address environmental and public health impacts on minority, low-income, and indigenous communities. Since the signing of Presidential Executive Order 12898 on environmental justice in 1994, the U.S. government has redoubled its commitment to focus on environmental and human health conditions of minority and low-income populations with the goal of achieving environmental protection for all communities. With respect to the concerns pertaining to pollution from extraction industries, such as uranium mining in the state of New Mexico and in the Navajo Nation, federal, state, and tribal governments are working together to identify contamination caused by uranium mining and milling, and to conduct and coordinate response actions such as assess water sources for contamination and assess and clean up uranium mines. With respect to the concerns regarding access to drinking water, public authorities throughout the United States take significant measures to provide access to safe drinking water and sanitation. There are state and local programs designed to help eligible low-income residents with the cost of their utilities. With regards to the U.S. government's engagement with all indigenous peoples in the United States, in July of this year, the EPA issued a policy on environmental justice, which affirms federally recognized tribes as the appropriate non-federal partners for making decisions and carrying out program responsibilities affecting their environments. The policy also makes it clear that the EPA is to maintain relationships with and be responsive to all indigenous peoples and communities, including state-recognized tribes, indigenous community-based organizations, Native Hawaiians, Native Pacific Islanders, and individual Native Americans. And I believe I may have a couple more seconds. Okay. I apologize for the rapid nature of this. I feel the challenges that the delegate from Ireland had yesterday. But finally, with respect to the concerns regarding environmental protection in Illinois, the state, in carrying out its commitment in 2 settled Title VI complaints of the 1964 Civil Rights Act, these settlement agreements reflect the active oversight of the U.S. government and the state's responsiveness to the civil rights concerns, which have resulted in the creation or enhancement of several components of the state's environmental justice program. I thank you, and I now turn to Paula Schaefer with the Department of State.
Thanks. I'm going to defer answering some of the questions that have been raised in the multilateral arena and just focus on one that was repeated several times, which is regarding the U.S. ratification of treaties or conventions to which we are not already a state party. This administration has placed great emphasis on the ratification of several treaties to which the U.S. is signatory but not yet a state party, and has placed particular emphasis on both CEDAW and the Convention on the Rights of Persons with Disabilities. As you know, however, ratification of these treaties requires a 2/3 confirmation vote by our Senate. This is in parliamentary terms, of course, a supermajority. It's very hard to get. Nonetheless, we've been very committed to working with our Senate to try to make progress on these treaties. And unfortunately, as you know, there was a very close vote last year in the Senate on the CRPD. It did not pass. We are hoping that in this upcoming year and session, we'll be able to get that particular treaty through. So with that, I know that we're completely out of time. I think I had negative time to answer my questions. I'll just stop, but I'm really happy to talk to any of you afterwards on specific multilateral questions. So thanks so much.
Bueno, muchas gracias.
Thank you very much to the distinguished delegation. On my own behalf and on behalf of my colleagues, I'd like to thank the delegation for the extensive replies they've given to the questions asked yesterday, and the way they've been able to answer the questions asked this morning as well. Some questions and comments have remained unanswered, and I would invite the delegation from the United States to send us further information in writing by tomorrow afternoon at the latest. In that way, we will be able to include that information within our subsequent discussions to make it part of our concluding observations. So that's by tomorrow afternoon at the latest. We've received an awful lot of information, and I'd like to thank the distinguished Ambassador Harper for helping provide that information. We've seen that there is criminal jurisdiction to combat, for example, discrimination against women, and we'd like to hear more from you about the case, the Oliphant case, where in 78 the tribes lost jurisdiction, or lost their criminal jurisdiction. As regards the federal immigration law, this does recognize the right for American Indians to enter the United States born in Canada, as long as they have at least 50% of American Indian blood. We have information of 2 specific cases that currently this section 289, which codifies Article 3 of the EA Convention of 1974, but Article 3 does not mention the blood level, the quantity of blood, and that was codified for the first time in 52 during the determination era. This is a federal Indian policy, and I'd like to know the United States position on the compatibility of that provision with the requirements of CERD. civil society is concerned about criminalization of homeless persons. And it is important for this committee, for the distinguished delegation, to share the measures being taken to ensure non-criminalization of homeless persons. I'm also concerned by information received regarding the disparity on populations of indigenous persons in Alaska. 15% of the total population compared to the total prison population, 70%. And one last question. Global warming is affecting all peoples, but there is a disproportionate risk of environmental disasters for persons in many places in the world, including indigenous peoples of Alaska. They are experiencing destruction of their lands, which were previously part of permafrost, and the destruction of their habitat. So I'd like to know what efforts are being taken to promote or to amend the losses of such land for indigenous peoples. Having slipped in those last few questions, I'd like to thank the delegation for their preparedness to dialogue with us and to answer almost all of the questions put. We've been delighted to receive so much information from you. I'd like to also thank conference services for having given us the extra time this morning. We do welcome that extra time given to us by the interpreters, and having done so, I'd just like to give the floor very briefly to Mr. Amir for him to introduce his preliminary conclusions. Thank you.
Monsieur le Président, Monsieur l'Ambassadeur.
Mr. Chairman, Ambassador, I'll speak in French as I conclude, because some colleagues asked me to. Mr. Chairman, we've taken note of all the responses to our questions. The committee will have a meeting to adopt our concluding observations. And the number of questions and replies was significant. Given the time that we had, we don't have any time left actually. And so I would just recall some of I'll just talk about some of the concluding observations that I'll submit to the committee, and which in the end will be conveyed to the government of the United States. But for right now, to conclude, I would just like to thank not only the ambassador, but also all of the members of the delegation of the United States for their very specific responses. Their replies were very concise to all of the questions that were raised by all of the members of our committee, including the rapporteur. What is important, the most fundamental thing, is the very constructive nature of our dialogue. The dialogue was characterized by human intelligence, and that is due to the quality of the dialogue. Mr. Chairman, Ambassador, we will continue our path to combat all forms of racial discrimination. But what motivates us in the end, in our combat against racism and ensuring equal rights, one name that history can never forget is Dr. Martin Luther King. Thank you, Mr. Chairman.
A usted, señor Amir, por su...
Thank you, Mr. Amir, for having introduced your preliminary conclusions and comments. Your Excellency, Ambassador Harper, I now give you the floor to wrap up this morning's meeting and the dialogue. You have the floor, sir.
Mr. Chairman, on behalf of the United States government, I would like to thank you, the Rapporteur Amir, and other distinguished members of the committee for hosting the dialogue on our common commitment to eradicate racial discrimination. These discussions have been collegial and very stimulating. We understand the level of interest by committee members, and I think we share our disappointment in not having a sufficient time for interactive dialogue, especially given the large senior delegation that's traveled here. Nonetheless, we appreciate the role of reporting process under the convention and echo the committee's appreciation for the valuable and extensive participation in this process by civil society. We will have much to reflect upon as we continue our work on this most important topic. We look forward to receiving the committee's concluding observations and at the end of the month and for our continuing dialogue with this committee. Thank you so much.
A usted, señor.
Thank you very much, Your Excellency. Thank you very much for those words. That then concludes the analysis of the periodic report of the United States of America. I hereby close the 2300th meeting of the CERD with the information that at 1:45 we have an information meeting with the Peruvian NGOs in Pali Wilson. So that's for committee members. Enjoy your lunch. See you this afternoon.